Good evening, everybody. I'm Nate Eaton with EastIdahoNews.com. Welcome to Courtroom Insider. We have a special edition tonight because there's so much news. I wanted to come on tonight and not wait until tomorrow, Thursday night, when we normally come on with Courtroom Insider. Tonight, we have some news in the Lori Vallow case and an expert who is going to fill us in about why Lori Vallow might decide to represent herself, why anybody in general would decide to represent themselves. You know, you are charged with a crime, and I think most of us would say, I want the best attorney out there. I want to get the best attorney out there, the best team of attorneys, whatever I can do to be sure that I go through this, and if I'm innocent, I'm released, or if I'm guilty, at least I, have the least penalty possible, or whatever you might think. But Lori Vallow is representing herself, and we can see kind of where her mind's going based on some filings that she has just submitted to the court, or I guess I should say that actually just became public today, within the past few days this week, and I want to share those with you. Before we get going, though, would love to know where you're watching from, and would love to know if you have any questions about the Lori Vallow trial, which begins in a little over 2 months from now in Arizona. I do know that she has her investigator working, interviewing people, meeting with people, gathering facts for her defense. I don't know how broad that's going to be, while the prosecution is also doing their work and preparing for that trial. Remember, in Arizona, Lori has been tried with 2 crimes, or charged with 2 crimes. She hasn't been tried yet. One was for the shooting death of her 4th husband, Charles Vallow. He was shot and killed by Alex Cox back in July of 2019. Lori Vallow was there with her son, JJ, and daughter, Tylee. Remember, they then left the house. They stopped by Walgreens to pick up flip-flops. They went to Burger King to get a breakfast, and then she took JJ to school. And then they came back to the house where police were beginning to investigate the shooting circumstances. We've seen the body camera footage. It's been all over the place. Lori Vallow out there talking to the police. This is just a clip of it.
Does your husband live here or no?
No, he lives in Houston.
Gotcha. Okay, you guys
We're
met.
separated.
Gotcha. Okay. Let me just get do you have a driver's license with you I can just grab?
She's smiling, she's laughing. She obviously doesn't seem too distraught that her husband is dead. They then went down to the police station where Tylee and Lori were interviewed. And it turns out that Alex Cox then died months later, and this whole thing came to light. So Lori's being charged with conspiracy to commit Charles Vallow's murder. That is the trial that's happening beginning March 31st in Arizona, Maricopa County. There's another trial that will happen after for the attempted shooting death of Brandon Boudreaux. Brandon was on the way home from the gym. Brandon, by the way, was Lori's nephew-in-law at the time. He had married Melanie Boudreaux. They're now no longer together, but he was on the way home from the gym when he was shot at by Alex Cox out of Charles Vallow's Jeep, and he called the police. And that trial, we don't know when that one will happen. The judge has told Lori Daybell that one will happen after Charles Vallow's trial this spring. So that brings us, that's the background setup of what has happened this week. Lori Vallow is acting as her own attorney, and she has filed some documents, some motions. In fact, I'll just read it to you. It's a motion to dismiss. She wrote this with a pencil or a pen in jail because she doesn't have a computer. And this is what she said. She is asking the judge to dismiss for lack of a speedy trial. The defendant, Lori Daybell, requests this court to dismiss case with prejudice. That means dismiss it and you can't file it again. Facts. 1. The defendant, that's misspelled, the defendant, was extradited from Idaho on November 30th, 2025 to Arizona. Okay, already 2 typos in that first sentence. It wasn't 2025, it was 2023, and she spelled defendant wrong. Now, I'm not going to get all over her for doing that. I misspell things all the time. But these are court documents. And if you get dates wrong, that can have significant impacts. Recall in Chad Daybell's trial that the prosecution got the dates wrong on one of the charges. At the very end of the trial, Judge Boyce's staff attorney caught that the date was wrong. Because the date was wrong in that charge, potentially you could say the state didn't prove that the crime happened during this date frame because it didn't, because the dates were wrong. They got it fixed. It didn't affect the outcome. But she's saying she was extradited on a date that hasn't yet happened. November 30th, 2025. Okay, so let's move on. Fact number 2, she says, the defendant was arraigned for 2 separate charges on December 7th, 2023. A trial date was set at that time for a speedy trial on April 1st, 2024. A speedy trial must commence within 150 days. 4, the judge deemed the charges complex, which gives the state 270 days to give the defendant a speedy trial. The new trial date was set for August 1st, 2024, with the last possible day to begin trial September 2nd, 2024, to be in compliance with a speedy trial within 270 days. The former defense team filed a motion for continuance, which the defendant objected to on the record, but it was granted, and a new trial date was set for February 24th, 2025. A Rule 11 was also filed by former defense team, further delaying the trial, and a new trial date of March 31st, 2025 was set. We'll pause there. A Rule 11 is a mental evaluation. That's what they call it in Arizona. A Rule 11 is basically to find out if you're competent for trial. Number 8, it has now been 314 days since the defendant was arraigned. Number 9, on January 10th, 2025, Judge Bursky declined to set a trial date for CR 2022, the Brandon Boudreaux case. Then we have number 10, the trial date that is set on March 31st, 2025 is for CR 2021 only, meaning Charles only. It is the position of the defense that no trial date has ever been set for the one case. This alleged crime occurred over 5 years ago. The state of Arizona has had plenty of time to figure this out. At no time has the state ever been willing to combine these 2 charges into one trial. Well, they're separate charges, and the indictment numbers are different. They were filed at separate times. The state has maintained from the beginning that there will be 2 separate trials with 2 separate juries. Therefore, why did they not schedule 2 trials at the arraignment? Why did the state arraign the defendant for both cases on the same day, knowing they could not provide 2 separate speedy trials? The state had 5 years to figure this out. If the state would have arraigned the defendant on one charge and then arraigned the defendant on the second charge 1 month later, then 2 speedy trials could have been maintained. This state failed to do so. By March 31st, 2025, it will have been 394 days since the defendant was arraigned. The defendant has never waived her right to a speedy trial. The Sixth Amendment declares, and she quotes the Sixth Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. In the state of Arizona, the designated speedy trial is to be within 150 days of arraignment. If the case is deemed complex, then the date of a speedy trial is extended to 270 days from the arraignment. No trial has ever been scheduled for the one case. Therefore, the defendant's constitutional rights have been completely violated by the state of Arizona. The only remedy to this violation of this defendant's constitutional right to a speedy trial is to dismiss the case with prejudice. At no time has a trial been given for the case. At no time has a trial ever been scheduled for the case. The defendant's constitutional rights have been violated. The government must follow its own rules. An evidentiary hearing is requested. Lori wants a hearing to talk about these alleged violations. So, there you go. I don't think this is going to change the course of anything. I don't think the judge is going to drop the case. I don't think that look at in Idaho, she was charged in 2020 Her trial wasn't until 2023. Chad's wasn't until 2024. He did waive his right to a speedy trial. She did not. But it's fascinating to see her file these motions. It'll be fascinating to see how the judge rules. He has ruled on her other motions, denied them all. And so this leads me to our guest tonight, David Leroy, former Idaho Attorney General, former Lieutenant Governor. He's had decades of experience practicing law in the state of Idaho. And I wanted to just really talk with him about why someone would decide to defend themselves. Why not have a team of attorneys? What is the benefit of having you represent yourself versus having an attorney? What is at risk with the court system if someone tries to defend themselves? Also, what will happen with the trial? He says, and I would have to agree that because Lori Vallow is representing herself, this trial could go a lot quicker than if she had defense attorneys. Her trial in Idaho went so much quicker than Chad's because she didn't put on a defense. She didn't want a defense. She was leading that defense team. Chad Daybell's trial was longer. It was also a death penalty case, so there was more to talk about. But his trial was longer because his attorney put on a defense. So I chatted with David Leroy today about these aspects, about why someone would represent themselves and what could happen, what are the risks and whatnot. And here is that conversation. I guess the first question I have for you, David, is why would somebody decide to represent themselves?
Well, there can be several approaches to that, depending on the defendant, the case, and the circumstance. Sometimes it's simply a dispute with their retained lawyer or their public defender lawyer, and they decide, I want to go ahead, but I don't want to take a delay. I'll just do it myself. I'm perfectly competent. Sometimes it's some sort of illusion about the relationship they have with the Constitution and their right to be a sovereign entity in and among themselves, and there's no need to delegate to a third party, even a professional, etc. And sometimes it's just a general detachment from reality and not really knowing the circumstances of what they're in, how to go forward, and the best way to get there. There's no one answer. It's complicated and situational.
All of those reasons you just described, it sounds like there's a little bit of Lori Vallow in all of those reasons that you described. She definitely does not want her trial delayed. She appears to think she knows more than her attorneys or has had disagreements with them. And I'm sure there's a whole list of other reasons why she's doing it. What are the risks that happen with court proceedings when someone decides to represent themselves if they've had no legal training, if they're not an attorney?
Well, the risk is, and the rule is, that if someone is allowed to go forward and insists on going forward, as is their right without counsel, they are treated to the same standard procedurally and result-wise as if they were a law-trained and licensed attorney. So if someone makes a mistake in procedure, they're bound by that mistake. If they get a result that is untoward and unfortunate, that a professional might have helped them avoid, they're bound by that result. So the courts have to treat someone acting as an attorney as if they were an attorney from a result measured point of view, looking backward on appeal, identically as if they were going forward in the courtroom. Now, I presume that in a very serious case where perhaps even a death penalty case, the appellate courts might be a little bit more flexible about some kind of mistaken judgment or mistaken procedure that was brought on by the defendant's own inexperience. But generally speaking, the rule is if you want to act as a lawyer, you're held to the competent standard of a lawyer.
So when the trial actually comes to happen, comes to fruition, does someone representing themselves get to make an opening statement, get to make a closing argument, get to question the witnesses? Is it pretty much like a normal trial, even though that person's on trial?
It's theoretically identical as to a trial. And of course, the frustration and the loss of efficiency that is occasioned by someone learning on the job in that situation is often very problematic for a judge or a jury or the other side represented by counsel that's trying to move forward in a logical path to an efficient result. For instance, if someone is going to take the stand to testify as their own witness and acting as their own lawyer, the procedure that's supposed to be in place is that the person as lawyer will ask themselves a question. Where were you on Tuesday night at 5 o'clock? And then they will put on a different hat and answer their own question. I was home with my wife. And that kind of thing is supposed to mimic in transcript form exactly what would happen if there was both a lawyer and a witness or a defendant involved in the process. So yes, the defendant lawyer gets to make an opening statement and closing argument. The defendant lawyer gets to cross-examine witnesses and is presumed to ask relevant and appropriate questions. And the individual is entitled, if they wish to take the stand in their own defense and, as I've just indicated, answer questions posed by themselves.
Yeah, I think in Lori Vallow's case down in Arizona, the judge said if she decides to take the stand, she needs to write out the questions, as you said, and one of her advisory attorneys will read them to her. It's not like she can just go up there and talk.
Correct. It's objectionable if you don't have a question and an answer, generally speaking. It's the objection is narrative form. We're entitled to questions, Your Honor. And so that someone can object to an answer before it's given if the question is framed improperly.
Have you ever seen someone representing themselves who actually does a really good job and perhaps gets off?
Yes, from time to time, we've had people at every level of court, magistrate level, district court level, and occasionally on appeal before the Supreme Court that gave themselves sufficient tutorials and had sufficient facts to be successful. It's a constitutional right, sometimes successfully invoked.
Another question I have kind of related to this is often you'll see attorneys that might be charged with a crime who then get an attorney, and you might think, well, they're an attorney. Why don't they just represent themselves? Why would you want to bring on counsel, sometimes multiple attorneys to assist you?
Well, there's an old adage that the attorney who represents himself has a fool for a client. That may or may not be true in every case, but it is a significant subtlety that as an advocate, you can take positions, you can be indignant, you can pontificate in the courtroom, you can anger the jury as lawyer in ways that you shouldn't do that as defendant or witness. So having a yin and a yang in the courtroom, an advocate and an innocent client or a long-suffering client or a believable and empathetic client is often very different than the kind of projection you need to make to that same group of fact finders as lawyer. So I would say that lawyers who have lawyers are doing it right rather than trying to, once again, have a fool for a client.
Right. Well, if anything on these high-profile cases, if someone decides to represent themselves like Lori Vallow, the interest level seems to go up dramatically with the public, especially, I imagine, when that trial starts and assuming it's televised. I mean, it might be must-see TV for a lot of people.
Well, that may be. I mean, there certainly is injected the potential of a circus element not usually seen in the courtroom. But what happens most frequently is that the trial proceeds with very swift and predictable outcomes because the negatives or the contrarian points of view that should be developed simply aren't developed because the defendant acting as lawyer doesn't know the right questions, doesn't call the right witnesses, doesn't make the right objections. And so what might promise to be great theater ends up sometimes being a very swift and predictable outcome that takes less time than otherwise might have been the case.
Yeah, that's a really interesting point.
Yeah, I'm sorry for that choice. In most instances where it's presented, it's problematic all the way around, but most problematic most often for the defendant himself or herself.
And I noticed in Lori Vallow's particular case, the judge was very clear when he questioned her when she said, "I want to be my own attorney." He got it on the record of, "You're doing this voluntarily. You understand that your attorneys right now have more hours practicing law than you do." I mean, he really got it on there. Was that mainly for appellate purposes?
Well, I think for appellate purposes, but also to truly plumb the depth of her commitment, the depth of her decision, and the depth of her understanding of the ramifications of that decision. She has, though I haven't followed the Arizona case with any particular acuity or depth, she has either from jail or in the process of that expressed what seems to me some distancing from factual reality and making sure that she's in touch with where she is, what she's doing, what's at risk, and what she really wants to do is a present moment decision in one regard, but certainly it's building a record that will survive on appeal should the outcome be a conviction. That's very significant for a district trial judge, but also trying to understand where she is and what's really motivating this decision.
Anything you want to add, David?
No, I'm delighted that you've been such a focal point and lightning rod on all of these very important cases, and the fact that you've covered so well this Vallow Daybell set of cases has, I think, been one part of Idaho being able to show itself to the world as an appropriate font of justice, even in high-profile cases. We had in some of the television networks and some of the prognosticators, both of these individuals convicted well before they were tried. And the fact that you carefully, slowly, accurately presented to your viewers and your readers what was going on in both of these cases has been a great asset to Idaho. So my compliment to you, to East Idaho News, for not only what you've done to date on the Lori and Chad cases, but what you continue to do. It's important that we understand that, and you have projected Idaho well to the world in the criminal justice situation, showing that we are indeed willing to comply with the Constitution.
No, you're very kind. Thank you. I always say I'm just doing my job. This is fascinating to me to learn the court system, to learn how it all works. And of course, I'll be back in Boise, your neck of the woods, later on this year when Brian Kohberger goes to trial, as will a whole lot of other people.
Well, fill out your application. I'll walk over with you to the University of Idaho College of Law, and we'll get you in the freshman class.
Hey, sounds good. Sign me up. Oh man, that sounds exhausting, but interesting. And my thanks to David Leroy for always being willing to chat with me about these issues and for being so knowledgeable. We talked about Kohberger. Tomorrow, Brian Kohberger is back in court in the morning. We're going to live stream that hearing on eastidahonews.com, my Facebook page, our eastidahonews.com Facebook page, and our YouTube channel. Starts at 9 a.m. Mountain Time. You can tune in now. The judge has said that there will be, it'll be broadcast. I'm going to read to you the exact language because some of the proceedings, some of the hearing will be closed to the broadcast. So we'll have to go to like a standby graphic, if that makes sense. But other parts will be shown. So, per a new order of the court, public portions of the hearings scheduled Thursday and Friday, so there's 2 days of Kohberger hearings, in State versus Kohberger will be live streamed. However, per the order, the courtroom itself will not be open to the public because of the need to revert to sealed proceedings on and off throughout the hearing. So it's going to be a really interesting hearing because there'll be stuff that's on the record and then the judge may say, okay, we need to go into a sealed portion. It will then cut away and then come back on the record. So it could cut away several times. It will begin at 9 a.m. with the closed portion for certain testimony related to the defendant's motion to suppress genetic information. After the testimony is done, the rest of the hearing will be streamed publicly, though the order states the court could close further proceedings if necessary. So, 9 a.m. it starts, but it'll be closed in the beginning. No idea. You can just tune in, though. We'll start the live right at 9, and then as the time goes on, we'll bring it up when it comes in full. And then what we will do is tomorrow night, 7 o'clock Mountain Time, that's Thursday night, we will talk all about what happens at the Kohberger hearing, plus a special guest who has written a book about the Kohberger case and what it means and what he's learned and all things Brian Kohberger, that trial. So that will be tomorrow night, 7 o'clock, Courtroom Insider, but the hearing will actually begin at 9 a.m. I hope not 6 a.m., 9 a.m. Mountain Time. As for Lori Vallow's motion, back to the one we were talking about, we'll let you know when the judge sets a date, and maybe I'll head down to Arizona for that again. I'd love to go to Arizona. It is so cold here, and I would love to just be in Arizona, soaking up the sun. It was great. I was there a few weeks ago, but we'll let you know when that hearing is going to happen and how the judge rules. And we prepare for the trial, which will be coming up March 31st in Maricopa County. Thanks so much for watching Courtroom Insider. Be sure, if you can, please subscribe wherever you're at to our YouTube channel. You can follow me on Facebook. I'm also on Instagram, YouTube. You can follow us on all the particular channels so that you don't miss any news on any of these interesting cases. It will be an interesting year for court trials in the state of Idaho, or at least for trials related to the state of Idaho. Also, if you have any other cases that you think we should look at, go ahead and send me a message, because we're always looking for interesting, fascinating hearings and court things. And, it's called Courtroom Insider, so anything associated with the court system, would love to take a look at that. All right, going to hop off now. Have a great night. Thanks for watching. I'm Nate Eaton.